My name's Jami Amina. I'm part of the prosecution team prosecuting Mackenzie and others. We have been prosecuting these cases. There are 4. Now, let me just break them down for you guys. We have murder in Malindi. We have manslaughter in Mombasa Chief Magistrate's Court. We have Tononoka, where we have children offenses or offenses against children. And then we have Shanzu Law Courts, where I am sitting right now. We have radicalization offenses under the Prevention of Terrorism Act. Now, the other offenses that we have here include engaging in organized crime under the Prevention of Organized Crime Act. Now, to just differentiate these cases for you guys so that we are able to understand why we have 4 cases, let me begin by saying that the facts behind the Shakahola massacre are very notorious and everyone knows what happened in Shakahola. So let me not repeat what happened in Shakahola. But to just sum it all up, over 450 people died. And the deaths were driven by religion, cultic misinterpretation of good verses of the Bible, and that led to a situation guys decided that they want to go and meet Jesus in heaven. We all look forward to meeting Jesus in heaven. The way these guys interpreted the Bible, these members of this church called Good News International, the way they were preached to or ministered to, and the way they understood it and believed was that Jesus was not going to come, and they had to sacrifice themselves so that their souls would exit their bodies and join with that of Christ. So in plain terms, what happened was a suicide agreement or a suicide pact. For those who study or practice law, you'll check or consult section 209 of the Penal Code. It elaborates what a suicide agreement or a suicide pact is. So that's why we have manslaughter, because that particular section will tell you that where guys agree, and it's a common agreement between all of them, willingly to die, whether one kills the other or not. It does not matter how they die, for as long as they have agreed to take their lives, then that is manslaughter and shall not be murder. But in the process of the team, there's a big team with advice and directions from the DPP. When we looked at the file, we agreed together that children could not have been part of that particular suicide pact because of age capacity. So that is why we diverted and had murder registered in respect of the 192 children who died, who could not be part of that suicide agreement. And then the rest of the adults, who are 238, we charged them for the offense of manslaughter. Now, the number of people who we charged in the manslaughter case are basically all the adults who survived. The total number is 95. The total number of people who we charged with the murder offense, around 191 counts, are 32 in number. So someone might ask why the different numbers. For the murder, we decided to take the biggest responsibility holders, the people who bear the biggest responsibility for the crimes that happened against those minors. And we were able to identify a total of around 32 of the total 95. Radicalization basically is about the adoption or promotion of the extreme belief system that was adopted by these guys or promoted by some of them. So in that particular case, we have divided them into 2. You will find that the biggest responsibility bearers, who are those that are listed in the murder case, are appearing in these particular charges as the promoters of this extreme belief system. And then the rest of them, the total number is supposed to be 95, but since the case started, we have lost 2. The rest are now the adopters. And then the biggest responsibility bearers, again, are facing the offense of engaging in organized crime. Now, because we had kids who also survived, because not all of them died, and who have been the best witnesses so far, offenses were committed against them. Offenses related to cruelty, torture, offenses related to denial of their basic rights to basic education. So that is why we have that case in Tononoka, where the children now can be able to have their day in court who are living. Now, if you look at all these charges that I've spoken about, if we were to bring them all together into one court, we would have ended up with an overloaded charge sheet. Overloaded in the sense that we have so many counts. There would have been 238 counts plus 191 counts just to tackle the murder and manslaughter. And then we would have had an additional so many counts from the radicalization, and an additional so many counts from the Tononoka. So it made a lot of sense, both legally and factually, and for the ease of case presentation, case flow, and to make the burden manageable for the court and for the parties, we decided that it would be more effective to separate those cases. But essentially, the cases arise out of the same transaction. They are same series. The nexus is the same. The witnesses are the same. The exhibits are the same. We agreeably are using the same witnesses, evidently using the same witnesses in all the cases, so that in manslaughter, the same set of witnesses will also testify in the murder, and the same set of witnesses will testify in the radicalization, and the same set of witnesses will testify in the children offenses. But what we are doing is, where we have, say, 10 witnesses who speak to the same fact, we can have 3 of them testify in one court, and 2 of them testify in another court, and the rest of them testify in the other court, so that we are able to reduce the burden. But like every prosecutor will do, or any lawyer will do, when you have a witness who's also very good in expressing themselves, and they are able to also express clearly what happened, and you find that they have the clarity of mind to deliver the evidence in the manner that the prosecutor would desire to a court, the temptation is to use that particular witness and reuse them again. So what we have done is to ensure that we limit the trauma that may be visited on such a witness on account of them reliving the same testimony and the events that happened in Shakahola. We have counselors on board. We have residence counselors within the case, and then we have counselors also supporting the teams. One of the teams that is supporting us is the Witness Protection Agency, where most of the witnesses who are in Shakahola are hosted. And they are doing a very good job. Before the case comes to court, they do counseling. And then after a witness testifies, they also go on and do counseling.
My name is Musyoka, a prosecutor handling this Shakahola case. And the previous times that we've handled this case, it has gone smoothly. We appreciate all the parties that have been involved, all the stakeholders. Just to a quick recap on what took place this week, I would wish to summarize entirely that we took the evidence of a total of 6 witnesses, where the evidence majorly was about radicalization. We began with the one witness who had been stood down previously on the last hearing. In this respect of his evidence was for cross-examination. We really did well that he had participated in various instances at Shakahola, where he lost a child, he lost a wife, and therefore, indeed, he was a person of interest, and a witness who was stood out as very important to our case. We now took other witnesses, not forgetting that the first witness who had been stood down was a protected witness. We moved swiftly to now take other witnesses Major of those witnesses were protected witnesses, and many of them, in total, 4 of those witnesses were children, persons of who are minors. Entirely, those witnesses were telling us their stories, so to speak. The evidence was purely of how they were, told by their parents to leave their homes in company of their parents from various parts of this country and move to the Shakahola area, and in which they were taught that education was not important. And in fact, the words that were used is that education is bad. And they went ahead to tell the court that it's not important for them to seek medical, attention in the times when they are feeling, unwell. And again, those who are very small were not subjected to vaccination. That will tell you that how minors, if they are not vaccinated, where that leaves a child. Again, we were told that minors, and they were at all times told that they should not leave the well-known Shakahola area, which is now the Mackenzie area. And much of what these kids were also told that when they lived at Shakahola in Pastor Mackenzie's, confinements, that they were wateule. Wateule is a word that in a very same way, it has been borrowed from the Bible to mean that place was sacred and people living there were sacred. And the other people who were not living within Shakahola were known as Mataifa. In fact, the minors at all times made us laugh in court when they called us Mataifa, we prosecutors and the court and other people present. That is to say that their minds had been radicalized to believe that the faith that was being carried out at Shakahola was extreme, to the extent that indeed they found it not fit to leave the area, and therefore those few that we took this week, at one point, because the life was so extreme and it could not be bared, it was unbearable, so to speak, they had to escape by their own ways, by walking, trying to crawl at several times. Even one of them was arrested, beaten, and taken back and tied somewhere for them to die, as they said, to meet Jesus. Everybody wants to go to heaven, but that's not the way we should believe anybody should meet their Maker. And therefore, we really found it traumatizing as prosecutors, and traumatizing to those kids, traumatizing to everybody who had that evidence. We went ahead, and lastly, the last witness, who now was an adult and purely was a child officer, a children officer, so to speak, he came and narrated extensively on how during the years the Shakahola investigations were taking place, that is 2022 sometime and also 2023, that they rescued a total of 73 children. You can imagine that number is so enormous if indeed those children that were rescued ever died at that place. That would tell us we would have lost an entire society. That is to say, then the evidence that we were taking this week was purely trying to unearth on how the minds of all these good citizens were radicalized to believe that, yes, indeed, they were reading the Bible, but there is a different way of interpreting this Bible, so to speak, that it should make one believe is so different from other Kenyans, from other believers, and their belief is that they should go meet Jesus, and Jesus would never meet them on earth, and they should fasten their stay and movement to see Jesus. It should not take them, it should take them the fastest way. One of the witnesses said no one was allowed to take a bath, no one was allowed to take water, and again they should be allowed to stay outside in the sun bathing. You can imagine the sun in Mombasa, and one is living outside the entire day in a place where there is high dehydration and you don't take water. Indeed, that would tell us that their lives and their death would come very fast. And that's why we realized from the evidence, so many kids passed on within a short period. We also learned that no one, out of all those kids that were in Shakahola, no one ever sat in a class. There were no schools. They were not even allowed to move to go to the nearby schools. And the parents never took initiative to even guide the kids or children on how they can access school. That is to say, Other than the parents being the sole guidance, the persons that's supposed to provide guidance to the children, they were also participating in a big way to show them that school was not important. Not forgetting that their senior pastor that they called Mtumishi the entire time was properly educated. His kids, even up to date, it's mentioned that they've been going to school. And then, that is to say then, these kids that testified this week still have the desire to go back to school. Many of them have said, and in fact, one of them said he was traumatized to have left school when he was expecting to sit for the KCPE exam. He left school, and that year he never sat for that exam. Up to date, he has not sat for that exam, but he's working very hard to come back. Without leaving out that the trauma that I've seen in these kids, I must mention that one of them that was at the age of 17 broke down during the hearing. In fact, we had to take breaks, not once, not twice, but 3 times for this kid to be, have psychological guidance, a break for them to come back. And purely, this was brought about when we brought up the evidence on the photographic and videos showing the place where they lived. This kid could not believe when he saw how that place was and the picture that was taken and how he was emaciated at that point when he was rescued from Shakahola. The evidence of the day ended well by that evidence of the children officer, who then told the court extensively that indeed, if this was allowed to continue, we would have the society entirely wiped out. A social change would have been brought within Kenya as a region, knowing that if people don't go to school, it has a big social impact within the society. Again, if people are allowed to continue dying in those numbers as they are mentioned at Shakahola, definitely those people, the population would reduce in a great way and in big numbers. Lastly, just to mention that after today's evidence, the court found it fit to mention that we shall be coming back for further hearing, that is prosecution hearing, on the 28th, from the 28th of October to the 31st of October this year. So to speak, again, we shall be taking evidence of witnesses related or witnesses who shall be collaborating the evidence of these witnesses that have testified. That is to say, we need to further a bit on radicalization, being a key charge in these charges.